Now in session, the Chief Honorable Judge Gerald Glanville will preside in court. Now come to order.
All right, good morning, ladies and gentlemen.
Good morning, Your Honor.
All right, ladies and gentlemen, we are back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183 572. All right, let me go ahead and take roll for today. Let's see, Mr. Stillwell, Mr. Boston, Mr. Shar. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams. Good morning. All right, Mr. Kenrick and Mr. Weinstein. Good morning. Good morning. All right, Mr. Huey and Mr. Matthews Jr. and Sr., good morning. All right, Mr. Nichols and Mr. Garner, good morning. Mr. Ryan and Misty Williams, good morning. All right, Mr. Brown, Mr. Uhelski, Mr. Atkins, Ms. Love, and Ms. Hilton, good morning, counsel. All right. Okay, Ms. Knight, Mr. Kokomo, is he here? No, not yet. Okay, Ms. Haltwinger, Mr. Mansbach. All right, good morning. Mr. Smith? That's right, it is Mr. Smith. He usually sitting next to Mr. Brown. That's why I usually kind of get the two of you mistaken, but that's my fault, sir. I'll try not to let that happen again. All right, are all the jurors present, sir? Yes, sir. Okay. All right. Anything I need to take up before we call for Mr. Copeland? All right. Mr. Steele, you don't have to if you don't want to. I mean, it's okay.
I want to.
All right, go ahead.
I'm just, I don't know what is going on. Last we know, you said we're going to have a hearing with his lawyers.
I'm sorry, I didn't quite hear you talking a little low.
You said, I don't know what's going on. Last I learned, you said that there'll be a hearing this morning with his lawyer. It's been dark since.
He's had, okay. Mr. Copeland's had the opportunity to speak with his lawyer, Miss Bumpus, and it is my understanding he's going to testify. That's the latest I can give you, okay? So we're going to bring Mr. Copeland out, and we'll see what happens, okay?
Did the court send the immunity order?
It should be filed. It should be part of Odyssey at this point in time. Because it would have been filed, I think, on Friday, so.
I don't believe anyone.
Ms. Love, did you file that already?
We left the yellow envelope with the court for a signature. We were going to file it under seal.
You mean the motion?
It was the motion and the order.
Okay, all right.
We can give them.
Yeah, if you could send them a copy, that'd be fine. Okay.
Yes.
We're gonna need to send them a copy, so we'll send them a copy. All right. Can we bring out Mr. Copeland, please? right, Mr. Copeland, have a seat, sir. All right, good morning again, sir.
Good morning.
Okay. Sir, it is your intent to testify today, is that correct?
Yes.
Okay. All right. Summon our jurors, please, Sergeant Ingram. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Ladies and gentlemen, jury, good morning. Good morning. All right, we're going to go ahead and continue with Mr. Copeland here. So go ahead, Ms. Hilton.
Thank you, Your Honor. Mr. Copeland, good afternoon. Good afternoon.
I got to say it back.
You haven't said anything yet. On Friday when we left, I asked you how old you are. You said that you were grown. Can you please tell me how old you are?
Say that again.
Sure. Can you please tell the jury how old you are in numbers?
32.
And when is your birthday?
Say that again.
When is your birthday? I'm sorry. When is your birthday?
Next month.
Is that July?
I think so.
Okay. And were you born on July 25th?
I guess.
Okay. Are you from Atlanta?
I'm from Canterville.
Okay. Is that a section of the city in Atlanta?
I guess.
You guess? All right. And did you grow up in Mechanicsville?
For sure.
Did you say for sure? All right. And when you grew up, do you have siblings?
Huh?
Do you have brothers and sisters?
Yeah.
All right. And when you were younger, did you live with all of your brothers and sisters?
Overrule, sir.
Yeah.
Okay. I want to specifically talk about your brothers. How many brothers do you have?
Overrule, sir.
More than one.
Okay. How many?
I think 3.
All right. And what are your 3 brothers' names?
Overrule, sir.
Trey Nato Boss.
Say that one more time. You said it fast.
Nato Trey's Boss.
Nato, Trez, and Boss. Okay. Nato. What's Nato's given name? Or you just give me the first name.
I just did.
Nato.
Yeah.
Okay. Trez. What's Trez's first name?
Trey's.
Is Trez's first name Ron Trez?
I guess.
All right. And Nado, is that Rodney?
I guess.
Okay, and then what's the third nickname you gave me?
Boss.
Is Boss Rodriguez?
I guess.
All right. And when you were younger, did you go to school?
Yes.
Where did you attend school?
I don't know. I went to a lot of different schools.
Okay, what are all the schools you went to?
I don't recall all of them.
Or just tell me some of them.
I only know one. Slater.
Slater, is that elementary school or middle school?
Elementary.
Why you don't remember what middle school you went to? Did you go to middle school?
I think I did.
How long did you go to? Did you finish middle school?
Relevance.
Overruled.
Yeah, I think.
Okay. Did you go to high school at all?
Yeah.
All right. When you went to high school, did you go to Southside?
Yeah.
Yeah.
Overruled, sir.
Did you graduate from high school?
No.
All right. Do you remember what year you left high school?
No.
All right. After high school, did you work?
No.
What did you do after high school if you weren't working?
Say that again.
Did you do anything? If you weren't working, what were you doing?
I don't recall.
Okay. Are you married?
Nope.
Are you in a relationship?
Nope.
Right. Do you have children?
You know that.
Okay. I do, but the jury doesn't. Do you have children?
Yep.
All right. How many?
More than one.
All right. Do you have more than 3?
I might. Ain't no telling.
Okay. That's perfect. That's fair. Do you have 2 that you know of?
Yeah.
All right. And how old are your 2 children?
The same age.
What's that?
I don't know. Y'all been having me in jail so long. I can't recall.
Okay. Were you in jail on Friday? Prior to?
Yeah, I was in jail Friday.
Were you in jail on Thursday?
Thursday ain't came yet.
No, last Thursday.
I felt like it.
All right. When you were in jail last Thursday, although you felt like it, how old were your children?
I don't know their ages.
Okay. Are you currently working?
I'm in jail.
Prior to going to jail on Friday, are you currently working?
Nope.
All right. Now, you talked about being in jail, which was on Friday. Prior to any of this, do you have any criminal convictions?
Of course.
Okay. Do you know offhand how many?
Don't keep up with it.
Okay. Tell the jurors the types of crimes that you've been convicted of.
Driving without license.
Okay. What else?
Driving with suspended license.
Okay. What else?
Ran in front of police.
All right. What else? Let me ask, do you have a theft
I'll be
by...
putting charges on me, so I go to jail for the charges y'all throw on me.
Okay. Do you have a conviction for theft by taking?
You tell me?
Do you recall having a conviction for theft by taking from 2009?
What did I take?
Yes or no?
I don't know what happened in 2009.
Okay. Do you recall having any convictions for aggravated assault?
Probably so.
All right. What about conviction for entering auto?
I don't know.
Okay. What about for terroristic threats?
What about it?
Do you have a conviction for terroristic threats?
I think they were with the aggravated assault.
Okay. What about theft by receiving stolen property?
I don't know.
What about possession of a vehicle with altered VIN number?
Never heard of that.
Okay. And what about possession of a controlled substance with the intent to distribute?
What's that?
Did you ever take a drug charge recently?
Oh, that's charge y'all put on me.
Okay. Did you plead guilty to that?
I had to.
All right. And did you recently plead guilty to possession of a firearm by a convicted felon?
Y'all put that charge on me too.
Okay. And did you plead guilty to that?
I had to.
All right. Your Honor, the state's going to tender State's Exhibit 382Y, 383Y, 384Y, and 385 Yankee, Your Honor, as self-authenticating documents. 382Y is the criminal conviction 15 SC.
Yeah,
Sure.
I'm getting to that, Mr. Steele, so.
this time, say like December 6th, exhibit 382, Yankee, 383, Yankee, 384, Yankee, 385, Yankee, 389, Yankee, 390, Yankee, 391, Yankee, and 392, Yankee, into evidence as self-authenticated documents.
Okay, any objections to states 392 Yankee, 383 Yankee, 384 Yankee, 385 Yankee, 389 Yankee, 390 Yankee, or 391 Yankee?
Yes, Your Honor.
Which one?
Not a complete objection, but some of those exhibits have strenuous plea forms in them.
Okay, well, there's two things. Remember what I told you. There's the plea itself, and then later we'll take up the other stuff. Yeah. Okay, all right. Subject to further ruling, I'll admit 382 Yankee, 383 Yankee, 384 Yankee, 385 Yankee, 389 Yankee, 390 Yankee, and 391 Yankee. They may be published as you see fit.
Thank you, Your Honor. And Your Honor, approach very briefly, please.
Yes. Mr. Copeland, remember we swore you in on Friday? Just wanted to remind you you're still under oath, okay?
Okay.
Okay.
Now, Ms. Copeland, in addition to some of those charges that we just discussed, did you also have a federal charge in 2015, a federal gun charge that you pled guilty to?
I did.
Do you recall having a federal gun charge in 2015?
You asking me or you telling me?
I'm asking you.
What you asking me?
Did you plead guilty to a federal gun charge in 2015?
I think I did.
Okay. Did you go to prison for that gun charge?
I pled guilty to it. I'm pretty sure y'all sent me to prison.
Okay. Do you recall how long you spent in prison?
You can remind me?
Do you recall how long you spent in prison?
No, I don't recall.
Did you spend at least 5 years in custody?
I think that's what they gave me.
When did you get out of prison for the federal charges?
When they let me go.
Do you remember what year that was?
One of these years.
Was it in 2024?
It's this year, ain't
Right.
nah.
Okay. Was it last year in 2023?
No.
Was it the year before that in 2022?
I think I was in Rice Street.
In 2022?
I think.
Okay. So then, did you get out of prison and then go to Rice Street?
Y'all locked me up so much. I can't read.
And let me say this: when we say Rice Street, are you talking about the Fulton County Jail?
Yeah.
Okay. But you went to Rice Street after you got out of federal custody.
I went to Rice Street. Nah, I think I got out on the street. And then y'all locked me back up.
All right. So then 2022, if you went into custody at Rice Street, did you get out of the federal custody in 2021?
I got out of feds in 2019.
Okay. Thank you. Now, Ms. Coleman, do you have a nickname? You're smiling. Do you have
Ask me a question?
Do you have a nickname?
Yeah.
What's your nickname?
Psycho.
Okay. Do you have another one?
Yeah.
What's that?
Woody.
Woody. And do you have a way that you spell Woody?
However people want to spell it.
Okay. And how did you get your nickname?
My mama.
And when people refer to you, do they refer to you as Kenneth, Psycho, or Woody?
All three.
All three. Which one do they use the most?
Objection, Your Honor. Relevance.
Oral, sir. That's not an objection, sir.
Which one do people?
Oral, sir. He said speculation. Oral, sir. That's right.
People who don't know me that good call me Woody.
Okay. And what about people who know you?
They call me Kenneth.
They call you Kenneth. Now I want to ask you if you know a few people, all right? First, do you know someone by the name of Shannon Stillwell?
What's his nickname?
SB. Or Shannon? Or Shannon Jackson? Stillwell, Shannon Stillwell, or Shannon Jackson, same person?
Yeah.
Okay. How long have you known Shannon?
We went to school together.
Do you remember which school?
I know one of them.
It was one of them. Okay. Was it elementary or middle?
Might be elementary or middle, one of them.
Okay. And I know I just said his nickname is SB. Is that what you call him?
That's what I call who?
Shannon.
No.
Okay. What do you call Shannon?
I call him Shannon.
And do you see Shannon in the courtroom today?
Well, I got a vision problem.
Okay.
I can't see that far.
All right. So if you want to stand up and look around the courtroom and look around the entire courtroom, tell me if you see Shannon in the courtroom today. Do you need to sit down?
Nah, I give me lightheaded. I ain't had nothing to drink.
Okay. Do you want some water?
You gonna give me a drink?
I'll get you some water.
I don't drink water.
Well, I don't have nothing else for you. But I will put some water up there for you.
Who am I looking for?
Shannon.
I think I see him.
Okay. When you say you think, you can have a seat. When you say you think you see him, what do you think he's wearing?
Look like he wearing gray over there.
So who are you pointing to over there that's wearing gray?
I think the lady got red hair.
Okay, so you pointing to a lady and not Shannon?
No, the one behind her.
Okay, so you're saying you believe that the person behind the lady with the red hair is Shannon. Is that what you're saying today?
Well, it looked like her.
Okay. Does anybody else over there look like Shannon?
Yeah.
Okay, who's the other person who looks like Shannon over there?
He's standing behind the bald head dude right there.
He's standing or he's sitting?
Sitting down, I guess.
Okay. What's his hairstyle?
Bald head.
So you're saying Shannon's the one with the bald head? Or he's sitting
No,
behind
he's sitting
him?
behind the dude with the bald head. I think that's him.
Okay.
It's two people with dreads. I can't see I just see dreads.
Okay. Let me just ask you this. Is Shannon from Atlanta?
I don't know.
When you first met him, where did you meet him at? Was it in school?
Ooh.
While y'all were in school, did y'all develop a friendship?
Nope.
At some point in time, did you ever develop a friendship with Shannon?
Yeah.
Okay. When was that?
I don't know when, but at one point we became cool.
Okay. And when you say cool, what do you mean?
COOL.
I didn't ask you to spell it. I asked you what you mean.
Well, we became cool. I don't know what you mean. I don't know.
Did you look at him as a brother? Was he an acquaintance? Was he just someone you talked to on occasion? When you define cool, what was your relationship like with him?
Oh, just a dude in the street.
That's it? Did that develop over time?
Say that again.
You said he was just a dude in the street. Did that relationship develop over time? Where he became more than just a dude on the street?
I guess.
Okay. And when you say, I guess, what do you mean?
What you mean? What do I mean? We became cool.
Okay. During the course of your coolness with Shannon, did you meet any of his family members?
Say that again.
As your coolness of your relationship developed, did you meet any family members of his?
No.
You never met any of his family members?
I never met none of his family members.
Okay. What about any of his girlfriends?
What you mean?
Have you ever met any of the people he ever dated?
I don't know how he seen him, but I done seen him with girls.
Okay. So you met some of the people that he may or may not have dated?
I guess.
All right. Now, when y'all were cool and you would see him in the streets, how often would you all hang out with each other?
What you mean?
How often would the two of you spend time with each other?
You gotta be specific.
Sure. Would the two of you go out?
I go out with anybody, even you.
I'm not asking about me. I'm asking about Shannon. Would the two of you go out?
We have went out.
Okay. How often have the two of you gone out?
I don't know.
Is it more than, let's see. You said you met him in middle school. You're 32. So roughly over the course of 20 years.
No.
No, you have not gone out with him?
I met him after me and him went to school, we never hung. I met him in 20 what? I met him in recent years. After we left school, in school we just knew each other. We didn't.
Y'all didn't hang out with each other?
No.
So about how old were you when y'all began hanging out with each other?
Most of our, whatever you trying to say, I was in jail. So.
But prior to you going to jail, did you hang out with Shannon?
I said yeah to that.
Okay. So my question is, if we're in 2024, I want you to think back your earliest memory outside of school when you would first start hanging out with Shannon.
Thinking back, all I remember is being in jail most of the time.
Were you in jail in 2014?
I've been in and out.
Okay. What about jail in 2013?
Yes.
Okay. Were you friends with Shannon when you were in jail in 2013?
I knew him.
Okay. You knew him? Are you saying you didn't hang out with him, or you just knew who he was?
Yeah, I knew who he was. I think that, I think I took a few pictures with him back then, but I don't recall, no, I'm lying. I knew him before 13.
You knew him before 13. Okay. About when?
I think I met him, I don't know if it was 2010, something like that. I don't know.
Okay. So at least at this point, about roughly 14 years. You know.
But I've been in jail most of that time, so
Did you all speak while you were in jail?
a few times.
So your friendship didn't stop just because you went to jail.
What you mean?
I stayed.
Did your friendship stop just because you went to jail?
Who
Or
determined when a friendship start and stop?
I guess you would.
I will.
Yeah. So did your friendship stop, or your coolness? Because you said coolness. Did your coolness stop with him when you went to jail?
Well, you know, in jail, out of sight, out of mind. One day I probably called or something. I don't.
Okay. You on permission to approach?
Hey, Judge,
Sir.
I'm hot. Can I take this sweat off?
We have to go into recess for school. Do it right there.
You want to recess?
Can we just we're going to recess, ladies and gentlemen, maybe about 5 minutes, okay? All right. All rise. And get your, okay. All right, ladies and gentlemen, please be seated. We're just going to recess in place. we'll probably break until about 12, till about 1:35. So I'm gonna call our jurors out and we'll go ahead and do that, okay?
All rise for the jury. Stand up for me.
Young, our jurors are present in the county.
All right, thank you, Lieutenant Walker. Ladies and gentlemen, please be seated. Ladies and gentlemen, jury, we've had to take up some ancillary business, and it's the lunchtime hour at this point in time. So what I was going to recommend we do is break until 1:35, come back at that point in time, and then we'll continue the afternoon. All right. All right. Okay. So we're in recess until 1:35. All right. All rise. All right, folks, we're in recess. See you then, back at 1:35. He is. He's right behind you.
Sorry. I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to me.
Is Mr. Copeland out?
No, he's a fence.
Okay, good. All right.
Yeah, come on down. Don't come in the courtroom. Come when you get to that.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a party,
yes.
A witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
Or
proprietary?
information that you should not be having that was ex parte.
Why?
With a party
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was
don't
coming
want to be
from.
held in contempt.
Well,
I'm
then,
not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me,
Don't have to.
If you don't tell me who it is, I'm going to put you. I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
All right, do we have everybody with here? Sergeant Ingram?
Yes, sir, everybody's present.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that, and it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well then, other than
Answer
if
that
you were
on the
if you were sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton. Or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have
When I got this information.
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I
for
understand that
mistrial.
you spoke with a
And
witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day.
court.
So
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
The state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
that leads to be told. But
But
State, do you have
right
anything
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section
because
1, paragraph
you've
4.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms. Love.
okay, excuse me.
Okay. All right. Yes, ma'am.
Your Honor, I am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as understanding there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right.
Your Honor. Have you heard?
Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right, sir.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carrington Matthews here on behalf of Mr. Mark Huey.
Okay.
We are also adopting all the arguments that have been made by
All right, sir.
Steele, by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time, and when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point means that we'll get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and
You don't have that luxury at this point in time, sir. You don't. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time.
I don't believe so.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, You have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you've made no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes. Mr. Adams in the hallway over there? Could you get him, please?
He's refusing to come in. Is he refusing to come in?
Wait.
Tell Mr. Adams if he needs to put some stuff on the record, please. Just hang tight, sir. All right, Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams, and I don't doubt that that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. and an appellate court will review my decision for abuse of discretion. So I'm going to direct that you go, that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking him for any other, or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect this court. I respect that the court has to do whatever is appropriate, but I would ask that the court also respect my representation of Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a fair trial, and we believe that that is the position that we're in. And I would respectfully decline the court's order for me to continue forward.
Your Honor, may I
Sure.
address the court? Thank you. Your Honor, there are two things at issue here, and one of them, Your Honor, is that...
Can I ask from the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recess, Ms. Love said that she was going to research this ethical issue, because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that. So far, this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made, at least by persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting. So that is the second matter. And first and foremost, we just ask that the court, again, allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right. That's fair enough.
Thank you.
Okay.
Your Honor,
Mr. Sharp?
the ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Your Honor, can I just
Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with. Sir, that doesn't alleviate the information or make it less valid or invalid. So, because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's great.
And like I said,
This is what
if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
my client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
okay, and that's your argument, sir. That's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not sun. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay. Well,
So
at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. Not saying that you may or may not get that information, but at this point, there was nothing that was improper about and the ex parte conversations. The court's more concerned about is the disclosure. So, and
I understand the court's concerned, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
And Judge, the only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present. His lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe in the application of Huey that the transcript is important.
Okay. Thank you, sir. All right. Let's get Mr. Steele out, please. You can tell him to put his tie back on. And then we'll go ahead and get started at that point in time, okay? All right, Mr. Steele, in the interest of your representation, continued representation of Mr. Williams, is been brought to court suggestion that you be here until when we've in all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court order the transcript that we can see it and have a hearing and call witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But I'm not at this point in time going to release any of the transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point.
Well, I was told based upon information belief that it would affect this witness's testimony from the jury, because I was told based upon information belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point in time. We're not going to argue about that right now. I just need, the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege if it happened before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't.
I'm trying to get out.
Well, that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you turn around and you say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well.
Has a right to be at, and I'd like to exercise.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say for what? You and Mr. Adams. and others. That is your right, and that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had a right to be there.
Well, all I know is what I told you, and there's more.
Okay, well.
There's a witness testifying who met with the court and the DAs. That doesn't concern us?
Your Honor,
Meaning the defense?
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in order?
In terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked for these particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important. It is important.
Okay. All right. So you got to think about it. All right.
Can I just, last thing, going forward, is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Stillwell, I'm going to review our Brady demand for any Brady material
Yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the District
Yes, sir.
Attorney's Office this morning.
Summon our jurors, please. Yeah, bring him out, please. That's fine. Summon our jurors, please.
to the present counsel, Judge.
All right, thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right, Ms. Hilton, go ahead, madam.
Can you hear me? Can you hear me? Okay. When we left after court, I'm going to approach you with some items. Your Honor, may I approach the witness?
You may have shown those to counsels already.
Yes, this is what they saw right before we took lunch. Mr. Copeland, I'm going to show you what's been marked as State's Exhibit 350Y, 351Y, 342 Yankee, and 356 Yankee. Can you take a moment and look at those pictures? Please look at those pictures.
Do I have to look at them?
Yes. I'm going to start first with State's Exhibit 350 Yankee. Tell me if you recognize individual in State's Exhibit 350 Yankee.
I recognize myself.
Okay. Do you recognize anybody else in 350 Yankee?
Myself.
Do you recognize anyone else in 350 Yankee?
Their face is covered up.
Okay. Do you see someone's face who's not covered up in 350 Yankee?
Yeah.
Okay. Do you recognize who that person is?
I can hardly tell.
Okay. Is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment.
Oral, sir.
I'm also going to object to showing the witness altered photographs.
Your Honor, it's based upon the court's previous rulings.
Not based upon it. It's not.
Let me see it. Can I see it, please?
We never discussed these photographs.
Chris, do we in 350?
The original as well, if you want to see the original.
Has 350 been admitted already? Okay, all right. Oh, you just so you're just showing him at this point in time. It's not been admitted, Ms. Hilton?
It has not been admitted.
Okay, all right. You have any further objections, sir? What's your objection, then? No, that's not an objection. What's the basis for your objection, sir? Do you have an objection as to the photo itself? Huh?
It's not best evidence. It's improper to show that photograph of the witness.
Your Honor, I'm not sure what Mr. Shard is calling altered. The only thing that has changed is based upon previous objections.
Oh, y'all want to come up? Excuse me.
I'm going to show what I'm now going to mark as 342 Yankee Oscar for original. Mr. Shard, do you want to come and see these? What is your objection? I'm now going to show you what's going to be 356 Yankee Oscar, 342 Yankee Oscar, 350 Yankee Oscar, and 351. Are those the same pictures that you just looked at? For the most part, you shake your head. You just got to say yes or no for the record for me.
Yeah.
Okay. Now, we were at 342 Yankee, right? No, we were at 350 Yankee. Besides yourself, just tell me everybody else you recognize in 350 Yankee.
You said show you what?
Besides yourself, tell me everyone else you recognize in 350 Yankee.
But you might name the people that's in the photo?
Yes, sir.
Me, Shannon, DB.
Do you know the fourth person?
I can't really tell your face.
Okay. Does that appear to be a fair, accurate depiction? So does that look like you, Shannon, and DB back in 2014? 2013, excuse me.
I'll sustain the objection. You can rephrase me.
Does that have a date on when this picture was posted to Instagram on there?
What you mean?
Does it have a date down here? Can you see that?
I can't see that.
Okay. But does that look like the three of you, DB and Shannon? Does it look like y'all?
I just said yeah.
Okay. Your Honor, this time the state would like to tender Stacey Exhibit 350 Yankee into evidence. 350 Yankee Oscar into evidence.
Any objections to states 350 Yankee Oscar? Hearing none, it's admitted, maybe published as you see fit.
Thank you. Now looking at 351 Yankee Oscar, do you recognize anybody in 351 Yankee Oscar? Who? Do you?
Wait,
Do you recognize anybody in 351 Yankee Oscar?
what you mean?
Do you recognize anybody in that picture?
Yeah, the same three.
Okay, so that you, Shannon, DB?
Yeah.
All right. And does that look like the three of you back whenever you all took those pictures?
It's my first time seeing this picture.
Okay, but is that y'all in the picture? Yes. Your Honor, this time the state would like to tender 351 Yankee into evidence.
Any objection to state 351? Is it Yankee or Yankee Oscar?
Thank you, Your Honor. Yankee Oscar.
On that, I was talking for yes, if you have objections.
We're going to not publish that version. We're going to get.
Okay.
We acknowledge what his objection is, and we have corrected it before we published it.
You want to show it to him?
If he can come over to Ms. Knight. Your Honor, state moves to tender State's Exhibit 351 Yankee Oscar attack.
Any further objection to State's 351 Yankee Oscar?
No, Your Honor.
All right, it's admitted and may be published as you see fit.
Next, Mr. Copeland, I want you to look at State's Exhibit 342 Yankee Oscar. Tell me if you recognize anybody in State's Exhibit 342 Yankee Oscar.
But this one?
Yes, sir.
It's blurry.
Okay. Do you recognize anybody in that picture, although blurry?
I can tell this me, but I can't really tell who the other people is.
When you say it's blurry, can you see anybody else on there, or you can't recognize no one?
Now I could see, but I can't really see their face like that.
Okay. Looking at 356 Yankee Oscar. Do you recognize 356 Yankee Oscar?
It looked like me.
Is there anyone else in there that you?
It most definitely me. I can't really tell who they did with me though.
Is that Shannon Jackson? Or Shannon Stillwell?
Nah, they dude got a mustache.
Okay, so is this your testimony that is not Shannon Jackson in this picture?
All I can say, I can recognize me, but I never seen their picture before, and I don't want to say that's him if it ain't him.
Okay. You have permission to publish 350 Yankee Oscar and 351 Yankee Oscar.
Yes, go ahead.
Now, first looking at 350 Yankee, are you able to tell us which one described by clothing? Where are you?
What you mean?
Which one of these individuals did you?
Which one on what?
Which point to you in that picture?
With the hat on.
Okay, there's 3 people with hats on. Which person are you with the hat on?
With the writing on my shirt.
Okay. What does the writing say?
DRC, third of YRC.
What does DRC mean?
DRC.
What does it stand for something?
You asked me what it means. DRC.
Okay, does DRC stand for something?
Not to my knowledge.
Okay. It doesn't stand for the robbing crew.
I'm not a rob.
Hold on.
Okay, that's fine. I'm asking you what does it
Hold
stand?
on. A sustained objection is to form. You can rephrase.
Okay. What does YRC stand for?
YRC.
Yes.
This stuff don't have no meaning. That's how I got this shirt.
Okay. That's your testimony today? That neither DRC or YRC mean anything?
That's how I got the shirt.
Okay. I understand that. I'm asking you, is this your testimony that DRC nor YRC mean anything?
I'll rule the objection.
Is that your testimony? That doesn't mean anything.
I said this how I got the shirt. So the shirt didn't have no meaning to it.
Okay. Who else do you recognize in that picture?
I just told you, me and DB.
Right. I saw it. The jury did not see
Oh,
it. So
my
I need
bad,
you
my
to-
bad, my bad.
Okay. So which one is DB?
He died.
And I'm sorry to hear that. Can you tell me who he is in the picture, though?
What you mean?
Just tell the jury, what is he wearing in the picture?
I can't really see what he got on.
Is he the one in the green hat, or the one in the purple, or the one in the blue New York Yankees cap?
You said green?
Is he the one with the green,
Okay,
greenish
yes,
hat?
I just didn't know the color.
Okay. So he's the one with the, like, behind you a little bit.
Standing behind me?
Yeah.
Yeah.
Okay. And then you said you recognize Shannon in this picture. Where's Shannon?
With the blue on.
With the blue hat on, the New York Yankees cap?
If that what it is, I guess.
Okay. All right. Thank you. And are you able to see on there the date of that picture, or is that blurry for you?
No, I can't see.
Okay. Looking at that picture, can you tell me about how old you were in that picture?
You look like I was in elementary school.
All right. But is it fair to say that it wasn't within the last 3 to 5 years?
Huh?
Was it within the last 3 to 5 years?
I've been in jail.
Okay. So it's fair to say it was before that. I just need you to answer for the record.
I've been in jail for the last 3 to 5 years.
Okay. So it was before that. This is yes or no?
I don't even know which one to say yes or no to.
Okay.
If I say yes, I'm saying yes to it.
The picture was before 3 to 4 years ago.
The picture when I was younger.
Okay. Next, can we please publish State's Exhibit 351 Yankee Oscar? Now, I think before you said those were the same 3 people in 351 Yankee Oscar. Is that you on the left with your hands up and you have on the shorts?
I'm standing to DB right.
Okay. So that's to my left?
I think.
All right. And then is that DB in the middle?
DB in the middle.
And is that Shannon to the right or to my right?
It looked like Shannon.
Okay. And again, about how old were you when you took this picture?
I don't know.
But it's fair to say that you were younger than you are today.
Say that again?
It's fair to say you were younger than you are today.
Yeah.
Okay. Do you think it was around the same time you took the other picture that we just looked at?
I can't say when.
Okay. All right. Thank you so much. Now, we spoke about your relationship with Shannon. As your friendship developed, did you all share personal information with each other?
What you consider personal information?
Did you talk to him about your secrets? Did you confide in him about life, things that had happened?
Nah, my secret go to the grave with me.
Okay. Were you someone, did you consider him like a brother to you?
Still do.
You still do? Now, outside of you and Shannon, did you all have another friend that you spent a lot of time with?
Meaning?
Is there any other person that the two of you collectively spent time with?
It's all 3 of us together?
Yes.
A lot of time together? I don't know about it.
Okay, is there someone that you spent time together with Shannon?
I spent time with Shannon with a lot of people.
Okay. Let me ask you this. You just said that Shannon, you still consider him like a brother to you. Is your relationship the same today as it was, say, back in those pictures?
Say that again?
Is your relationship the same with Shannon today as it was back when we were looking at those pictures?
No.
How has your relationship changed?
It's better.
It's better now? Why do you say it's better?
What you mean?
You saying it's better?
I barely knew him.
Is your relationship with Shannon the same today as it was back in 2014?
I can recall 2014. I've been in jail so much.
Do you know someone by the name of Demekion Garlington?
Street name.
Little D.
For sure.
How do you know Little D?
I didn't birth him.
I'm sorry, say that again.
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury, what do you mean by that?
I mean, he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him.
You heard of him. Okay, we'll talk about him in a moment. Now, the Little D that you said is like your son, is that what you said? How did you all first meet?
What you mean?
How did y'all meet? You say he like your
I
son.
don't know how we meet.
You don't know how y'all met?
Nah, I don't recall how me and him first meet.
Okay. How long have you known him? And if you're 32 now, just
I knew him I knew him longer than Shannon.
Okay. Did y'all grow up in the same neighborhood?
Probably, but we never hung.
How old do you think you were when you started hanging with Lil D?
I don't know.
If we're in 2024 now, did you start hanging with him when you were elementary school, middle school, or high school age?
I don't remember.
Don't remember.
I know when DB died, that's when I took him in.
Do you remember what year DB died?
I don't remember when DB died.
Do you know what section of the city Demekion is from?
No, I do not.
Did you all ever attend school together?
No, I can't go to school with my son.
Okay. Well, when you say it's your son, how old is Demekion? If you 32, how old is he?
I don't know. I don't know.
Is he close to aging for you?
What you mean?
Is he close in age to you?
He probably about 10 years younger than me. I don't know.
So you say Lil D is about 22 right now?
I don't know.
Okay. You said he's like your son. How often would you spend time with Little D?
What you mean?
How often did you see Little D? Back in, say, 2014, 2015?
I used to see him around.
Okay. How often?
I can't say.
You can't say? All right. Did you speak with him over the phone? Did you speak with him on the phone?
Speak who over the phone?
Little D.
When?
In any time?
Yeah.
Since you've known him? How often would you speak with him on the phone?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whole time.
And I understand until you answer the question, I'm going to have to ask you again. So was that every day? Was that weekly? Was that monthly? What was it?
I don't know.
I'll go back. In a week, how often would you see him?
What you mean? When are you talking about?
Back in about 2013, 2014. 2013 to 2015.
Well, he stayed with me.
Okay. When did y'all live together?
He didn't really stay with me, but he stayed at my residence.
Okay. Were you staying at the residence at the same time?
Well, I was in jail, so.
Okay. So while you were in jail, he was living where you live. Prior to you going to jail, which you went to jail in 2015, that fair?
I went to jail 2012, 2013, 2014, 2015, stayed in at 2019.
Okay. When you went to jail before 2015, were you in and out of jail?
When I went 2012?
In 2012.
2012.
How long did you stay in jail?
I got out 2013.
Okay. Did you go back to jail in 2013?
I got at the end of the year. I went back 2014.
All right. And then between 2014, did you get out of jail in 2014? Is that a yes?
Yeah, I got out.
And then did you go back
to jail in 2015.
2014. I went to jail like a couple times 2014.
Okay. So you were in and out.
Right.
And then in 2015, did you go back into jail?
Yeah.
And is that where you spent the long duration?
I went to jail a couple times in 2015. But the last time I stayed until 2019.
Okay. And it was the last time that you went to jail in 2015, June of 2015.
That was the last time, yeah.
Okay. And so prior to June of 2015, you were in and out that year between January and June.
Right.
Okay. In the periods that you were not in jail, did you and Little D ever live with each other when you were not in jail?
In 2015?
We'll start in 2015, yes.
Nah, he ain't stayed with me in 2015.
Okay. In 2014, those times that you were not in jail, did Little D stay
Right.
with you? And then what about 2013? The times that you were not in jail, did you and Little D reside with each other?
What you mean?
Did y'all stay with each other and did he stay at your home at any time in 2013 when you were not in jail?
2013 when I started to get to know him.
Now, you said that he's kind of like your son. Did you all share things with each other? I'm talking about conversations, personal conversations between you and him and vice versa.
Not no secrets.
Okay. But did you feel comfortable speaking to him? You did not?
Nah.
Okay.
I didn't feel, I don't know what you mean. Like, I didn't not feel comfortable, but I didn't feel, like, certain stuff we just don't talk about.
That's fair. Did you consider Little D like a brother? I know you call him your son, but did you consider him like a brother?
I consider him my son.
Okay. Do you recall ever telling any detectives previously that he's like a brother to you?
I probably did. Ain't no telling.
Okay. Y'all permission to approach?
Have you shown that to the defense counsels already?
Yes. Well, no.
Just make sure you show it to them.
I will. Permission to approach, Your Honor?
You may, madam.
Mr. Copeland, I'm showing you what's been marked as State's Exhibit 358 Yankee and 380 Yankee. Starting with 358 Yankee, do you recognize anyone in State's Exhibit 358 Yankee?
Yeah, me and my son.
Okay. Is that the person that you've been referencing as Little D?
Yeah.
All right. And looking at 380 Yankee, do you recognize the individuals in State's Exhibit 380 Yankee?
You said what now?
Tell me who you recognize in 380 Yankee.
Oh, me and Coco.
Who's Coco?
The ugly boy right here.
Okay. Do you see the person that you said is your son, little D, in that picture?
The restaurant got their head down.
Okay. Your Honor, this time the state would like to tender State's Exhibit 380 Yankee and 358 Yankee into evidence.
You said 380 Yankee,
Yes, Your Honor.
and what else?
358 Yankee.
Any objection to states 380 Yankee or 358 Yankee?
Yes, Your Honor. Lack of foundation, 380 as well as hearsay included on 380.
What about 358?
No.
All right, 358's admitted. Let me see 380, please.
And I can lay a little bit more foundation for 380 Yankees.
All right.
As far as the hearsay.
Okay, then go ahead.
Mr. Copeland, have you previously had an Instagram account?
Say that again?
Have you had an Instagram account?
Yeah.
And how many Instagram accounts have you had?
I don't know.
Okay. How many different names of Instagrams have you had?
2.
2. Okay. Has one of your accounts been 372 Woody?
I can't recall.
You can't recall. Okay. Are you Woody? That's what they call you, right?
For sure.
All right. And do you know any other Woody who hangs with you? Is there anybody else in your friend group that they call Woody?
Yeah.
Oh, how many other Woodies are there?
Jamie and the other one.
Okay. What's the other one's real name?
He died too. I don't know his real name. I think it's damn. I know his last name Bridges.
Looking at that picture, is the other Woody in that picture?
I can't tell because the other guys got their head down.
Okay, well, just look and see if you see someone who looked like the other Woody, even with their heads down.
Can you show me a clear picture?
When you say clear, what's not clear?
Because he got his head down, he got his head down. My hand covering his face.
Let me ask you this. When did the other Woody pass away?
Right before I got the feds.
When you say right before, meaning that year, a few months? What do you mean?
I got it like September, and somebody killed him, like probably, I don't know when, but they killed him before I got out.
Before you got out. Okay. All right. Looking at State's Exhibit 380 Yankee and looking at that picture with the 372 Woody, is that from your Instagram?
You talking about the one with all the people in it?
Yes, sir.
Okay.
Is that from your Instagram?
I don't recall this Instagram. My Instagram is Woody versus Woody.
Is that your newest one?
What you mean?
Is that the one that you currently have right now?
No, the one I currently have now is Woody _ self-made.
Okay. So are you saying you don't know if that's your Instagram?
I don't recall this Instagram.
You don't recall that Instagram? Okay. You're right.
If it's mine or not, I don't know nothing about it.
But do you see yourself in this picture?
Which picture?
The picture that's posted on this.
Yeah, I'm sitting right there, ain't it?
All right. And right here, you can't tell if you see the other Woody.
I can't. I can see me and him real clear. Both of us got our heads up.
All right. Your Honor, again, the state will still like to tender State's Exhibit 380 Yankee into evidence.
Let me see it, please. All right, any further objection to 380 Yankee, sir?
I don't actually, I'm going to withdraw my objection to that foundation. I do maintain my objection as hearsay. The foundation has not been made to establish the declarant, and also, regardless of who the declarant is, it's not a court statement that would be hearsay that doesn't fall under the
approach, please.
Published once it's submitted with the court's ruling.
Mr. Sharp, any further objection to states
I'm sorry, I didn't. 380?
Yeah, 380 Yankee.
No, you're
Okay.
nothing further.
All right. This is good.
All right.
Publish as you submitted.
First, we're gonna publish 358 Yankee. And looking at 358 Yankee, can you tell the jury, or tell the jury which of the two of you is little D, or who you call your son? Which one? The person to the left of you, right of you?
What you mean?
Is that little D to my right?
This lady in the picture with me.
Okay. And do you know about how long ago you took this picture?
No, I don't.
And we keep saying little D or your son. Do you know his given name? His real name?
No.
Do you know his real first name?
You said Demikian Garlington.
Okay. And is that the person that you know is little D?
This little D right here in the picture with me.
And is that Demikian Garlington?
This little D right here.
Is that Demikian Garlington?
If this was his name, then yes.
Okay. Now showing you 380 Yankee. And can you zoom in to the picture? Now looking at 380 Yankee, is that you sitting on the step in a white t-shirt and blue jeans and black and gray sneakers?
Yes.
Okay. And who's the other person you said that you knew in this picture?
The ugly boy right here.
Okay. And what is that? What is the individual that you pointed to? What's their name?
Coco.
All right. And in this picture, the person behind you with the 30 deep B, I think it's BITXH shirt on. Do you know who that is?
I can't recall who that is.
You cannot recall. Does that look like Demekion or Little D? Does that look like Little D?
The head cut off.
Okay. If you could, can you turn your chair around and look behind you?
What about it?
Does that look like Little D?
I guess.
Okay. Well, is someone you call your son? Does it look like the person you know
I
to be
can't
your
see
son?
that. I just told you that from the beginning.
Okay. All right. What, if anything, are you doing with your hands in this picture?
I'm doing nothing with my hand.
Okay. I want to go back to 358 Yankee. What, if anything, are you doing with your hands in 358 Yankee?
What you mean?
What, if anything, does what you're doing with your hands symbolize, if anything?
A bird.
Okay. Does it mean anything specific?
No, throwing up a bird.
Why are you throwing up a bird in this picture?
Because I'm from Mechanicsville.
Is that the symbol for Mechanicsville?
We represent a bird.
Okay. And then what about Demekion? Are you familiar with the hand gesture that he's using?
Say that again?
Are you familiar with the hand gesture that Demekion is using? And
Now, I don't know what that for to mean.
you don't know that. Okay. How is your relationship with Little D today?
Meaning?
Do y'all still have the same relationship that you had back in, say, 2015?
No, we don't.
How has it changed?
I wanted him to lie for me, and he wouldn't.
Okay. And when was that?
Back in the day.
When you say back in the day, what do you mean?
When the police was accusing me for stuff, I went to Lil D and told him what I wanted him to tell the police, and he wouldn't tell the police that, so I got mad at him.
Okay. And what year are we talking about that this occurred?
I don't know.
Are you speaking about one specific occasion or just multiple times?
No, I'm talking about one specific occasion, however you pronounce it.
And is your testimony that you have not been friends with him since that time?
Now, I have spoken with him, but our friendship ain't been the same.
When you think about your friendship with Demekion and your friendship with Shannon, at this point, who are you closer to, Shannon or Demekion?
Myself.
Okay. But outside of those, I'm speaking specifically about those two individuals. Between Shannon and Demekion, at this point, who, if either of them, are you closer to?
I don't understand what you're trying to say.
You and Demekion, that's like your son, right?
Right.
And you said that the two of you, I'm just trying to clarify for Mr. Copeland.
I'll sustain the objection. You can still rephrase.
You consider Demekion like a son. Is that fair?
I'll sustain the objection.
Who are you closer to today? Demekion, Shannon, or neither one of them?
God.
Okay. That's good that you're close to God, but I'm talking about Demekion, Shannon. Who are you closer to today? Demekion, Shannon, or none of them? Or neither of them?
I guess neither. I don't know how to answer that.
Back in 2013, 2014, 2015, that's the time frame we're talking about. How close was the relationship between you, Shannon, and Little D?
It was difficult.
You said it was difficult?
Right.
How was it difficult?
You just put 3 years together. So a lot happened within 3 years.
So let's first start with 2013. Describe for the jury your relationship with Demikian, Shannon, and Little D. Let's start with 2013. Tell the jury about your friendship and relationship with those two young men back then.
As in what?
Were you three of you close? Were you not close? Tell the jury about your friendship.
Look, I took special ed classes. You got to talk to me in a way that I can understand.
Sure. Back in 2013, were you friends with both Little D and Shannon?
Yes.
Okay. How close were the three of you back in 2013?
Again, my friend was killed. That's when I started embracing Little D.
All right.
In 2013.
When you started embracing Little D, were you and Shannon friends at that time?
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay. When did you, Little D, and Shannon start hanging together a lot?
20.
Did you, Shannon, and Little D hang out together?
Yes.
When did the three of you start hanging around each other?
The longest I've been out of jail was 2014.
To your knowledge, did Little D and Shannon strike that? How did the three of you all start hanging out together?
I don't know.
Okay. Did you introduce Little D to Shannon?
No.
Did you introduce Shannon to Little D?
No.
Okay. Did Little D and Shannon know each other before they knew you?
I stated objection.
Do you know if they knew each other before they knew you?
I don't know.
You don't know.
I don't recall how it started. I just know I started embracing DB, Lil D, after DB got killed. Lil D was more a DB friend.
After DB passed, you embraced Little D. Did the two of you start hanging out with Shannon after that?
I just said, how could I say this? Me and Shannon wasn't together in so long to be on the street. So I don't know when our three of us was able to get together. I just know at one point we used to go to the club together.
Did y'all do anything else besides go to the club together?
Yeah.
What?
Objection, Your Honor. May we approach? Sure.
So we said that you all would hang out. Did you all spend time at each other's homes?
No.
Okay. Did you all spend the time at other people's houses together?
What you mean?
Like, did you all go to other people's houses and spend time at other people's houses together?
We didn't spend time at people's houses, but we don't been, we go to people's houses.
Okay. You said you went to the club. Would you all go out to eat together?
Yeah.
Okay. Did the three of you go on any vacations together?
No, we don't do vacations.
Okay. Did you ever take any trips out of town together?
Not that I recall.
Were you familiar with any of Demikion's family? His mom, his
I know his mom.
What about Shannon? Did you know his grandmother or any of his other family members?
No, I didn't.
You have children. Did they have any type of relationship with your children, Little D or Shannon?
No.
Okay.
Not that I know of.
All right. What about you? Did you ever spend time? Let me back up. Did Little D have children?
Ain't no telling.
Okay. To your knowledge, does Little D have children?
Not to my knowledge.
All right. To your knowledge, does Shannon have children?
I think so.
Okay. Have you spent time?
Well, Shannon have children.
Yeah. Have you spent time with his children?
I have.
Okay. Have you taken them to birthday parties?
But my relationship with his children is not through him.
Okay. Who's it through? Their mother?
Yeah.
Okay. No permission to approach? Show it to him now, Your Honor. You have to look at this one. This one.
Mr. Copeland, I'm going to show you what's been marked as State's Exhibit 355 Yankee. $357 Yankee. $345 Yankee. $346 Yankee. $359 Yankee. And $374 Yankee. First, I'm going to start with $345 Yankee. Can you tell me if you recognize anybody in State's Exhibit 345 Yankee?
I can't recognize nobody in 345.
Do you see yourself in 345 Yankee?
The picture blurry. I can't recognize nobody in the picture.
Okay. Okay. We'll come back to 345 Yankee. I'm now showing you what's been marked as State's Exhibit 346 Yankee. Tell me if you recognize Exhibit 346 Yankee.
It's blurry as well.
Okay, so you can't see that. All right. Looking at 355 Yankee. Tell me if you recognize the individuals in 355 Yankee.
I do.
How do you recognize the people in 355 Yankee?
Because it's me.
And who else? Is there anybody else that you know?
Shannon.
Okay. Anyone else?
Yeah, and D.
All right. Your Honor, this time the state would like to turn the State's Exhibit 355 Yankee into evidence.
And objection State's 355 Yankee.
No objection.
All right, State's 355 Yankee submitted.
Now looking at State's Exhibit 357 Yankee, do you recognize anyone in State's Exhibit 357 Yankee?
I recognize myself.
Okay. Do you recognize anybody else?
It look like D, but it blurry. I can't tell.
Okay. Anyone else?
Huh?
Anyone else?
Yeah. I can't tell who this is right there.
All right. We'll put that in the blurry pile. We'll get back to that. Next, 359 Yankee. Do you recognize anyone 359 Yankee?
Yep. Me, Shannon, and D.
All right. Your Honor, this time the state would like to turn the State's Exhibit 359 Yankee.
Any objection State's 359 Yankee? All right, hearing none, it's admitted.
Thank you, Your Honor. And then last, State's Exhibit 374 Yankee. Do you recognize anyone 374 Yankee?
No, it's blurry.
Okay, so that's in the blurry pile. Court's indulgence for one moment. You're on permission to approach the laptop.
gonna show you. First things first, I want you to confirm with me. You see that says 345 Yankee?
To my this?
Yes. Does that say 345 Yankee here?
I guess, yeah.
Okay. Does that appear to be the same picture that's printed out on that paper?
It looked like it.
All right. Have I just made it bigger for you?
What about it?
Are you able now that it's bigger, able to identify the individuals that's in 345?
And what you asking me?
Tell me who you recognize in 345 Yankee.
Nobody.
So you don't see yourself in here?
To my this, in this
In
picture?
this picture right here.
This photo me?
Does it look like you?
I ain't never seen this picture before, so
Not that I've seen it before. Does it look like you?
yeah.
Okay. Do you see anybody else that you recognize?
I think they Lil D.
Okay. Does it look like Little D?
Mm-hmm.
Is that a yes for the record? All right. Do you see anyone who looks like Shannon in that picture?
No.
No.
They Lil Rick.
That's Lil Rick. Okay. Is there anyone else that you may recognize in that picture?
Done.
Okay. Anyone else?
That's it.
You say Don or Dot for the record?
Who?
The person that said, what's the name you just said?
Done.
Dot?
Yeah.
D-U-N-T?
Yeah.
Okay. Your Honor, this time to say like the 10 to 6 to get a 345.
Any objections, days 345 Yankee?
Yes, Your Honor.
Thank you.
I believe it's cumulative. The photos at this point.
That's it.
And I have a response to cumulative.
Come on, sure.
Yeah.
All right, let's take 10 minutes and then we'll see where we are then, see where the day leads us. All rise.
I got a headache.
We'll be in recess 10 minutes.
I might take the fifth.
Up the other matters that we have pending.
Yes, Your Honor.
All right, summon our jurors, please.
All right, so jury. For President County Clerk.
All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen, jury, how you doing? All right, listen, it's as you can see now, the hour is almost 6 o'clock, and there's some things we had to take up, so we're going to recess for the evening. Okay, so tomorrow morning, 9:30 for an anticipated 10 o'clock start time. All right, any ministerial inquiry of me? Okay. All right, ladies and gentlemen, let's go through your customary nightly admonitions. Okay, remember, as you leave here today, remember to leave your notepads in the basket. Do not discuss this case in ones and twos or back there as you are in your in your headquarters at your deliberation room, or as you're going back and forth to your homes of residence in our great county. Also, resist temptation as well to even as in ones and twos for you to discuss the matter. Remember, I told you that it would be a violation for you to recap or otherwise handicap the testimony as you sit back there, because remember, you can only consider this case properly and lawfully, bless you, at a time and place and space that the court kind of tells you you're able to authorize you to do that. Remember, you cannot seek the advice of any third parties, any third party websites, any research or reference materials, any other things that would allow any extra information, okay? Remember as well that if anybody should talk with you about this case in your presence or hearing, you need to, of course, let myself and Sergeant Ingram know immediately. And remember, you cannot go by any scenes that may be depicted or may have been talked about during this case at all. And remember, you can't take any pictures, discussions, or anything. So it's just that you're supposed to consider only what's been presented in this courtroom. All right, ladies and gentlemen, as well, thank you for your patience. Thank you for the attention that you've given this matter and the attention and patience you'll continue to give this matter. And unless you have any other ministerial inquiry of me, I'm going to release you till tomorrow morning at 9:30 for an anticipated 10 o'clock start time, okay? All right. All rise for our jury.
Who's speaking up? Okay.
Excuse me. Mr. Copeland. Sir, over here. Over here. It's me. The state has filed an order or request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay? So I will release you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm going to leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is that that's the case.
I'll be back.
All right. 9:30 tomorrow morning, okay?
All right.
All right. All right. We can let Mr. Copeland be released and processed.
And you have permission for the city to see Mr. Copeland about the
Say again?
Can we have options?
Yes.
I'm weak, man. Y'all can speak to me when I get out.
You go like this. Right. You can see him right there. All right.
That order, I'll go ahead and sign it, and I'll also make a copy of it as the next court's exhibit in order, and we'll e-file it this evening, okay? All right. Okay, Mr. Steele, are you willing to tell me at this point in time who it is that disclosed this information to you?
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come in.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call, but
Okay, and that's
let me just finish.
okay.
Because you said to me that you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. But they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just
Or they're not in your courtroom.
we just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And
8H then has to have a right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. Well, we'll let Ms. Merchant in.
Defense.
That's fine.
Ashley Merchant.
Yeah, Ashley Merchant.
Ashley Merchant, yes. Right, Ashley Merchant is present.
All right. Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt. I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then, as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So he can, I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and it's very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
That'd be great. Thank you so much. Just for the record, Ashley Merchant.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia App.
Georgia App.
372.
Okay.
Also 215. Georgia App. 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those. Do you have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other cases. And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've got space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H, and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys, they're all members of the bar. I can give you all their
They
names.
still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom, so we would ask that they be
I
allowed to.
don't want them in my jury box, okay? No.
I understand. May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney, co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susser. Alex Susser. Thank you, Judge.
Henry Adams, it has two issues. One is the motion for disqualification, okay, and that's and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't think Adam. I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case. Just a second.
And there's several others when you're ready. Yes. It may be one I have too.
Hasty's conduct didn't rise to a level in this system warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
oh, those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also,
You said 279 Georgia what, I'm sorry?
Georgia 13.
Georgia 13?
It's a 2005 case.
All right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
See, but you all are covering under, let me see.
I'm sorry, Judge?
Hold on. Just a second. Pardon me. Contempt is directed. The trial court has the power after confording the contempt order to opportunity to speak in his or her own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So.
And Judge, there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you, because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you. Okay.
I believe that the court has put him in that position.
No,
he cannot be held in the law states McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt. So
you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there, because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that, because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay. Well.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
But you got the information. But here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case. He has filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
just the case law on that is in Ray Hughes.
Hold on.
Right.
The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So, you don't get a supersedious on that, on a criminal contempt, respectfully.
So, Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that, in fact, I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Well, Judge, I think I'm addressing a slightly different point of law.
It is. Hold on, sir. 1 second. I'll give you two cases. One is it's Untema. It's UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there is another case that I'd invite your attention to, and that is
Syverson. It's Syvertson, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other...
I'm not going to grant him a supersedious bond.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt,
That's civil.
Judge, and that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm going to take 5 minutes out and I'm going to think about it.
Thank you.
Okay? All right. So we'll be in recess about 5 minutes. All right, thank you, madam.
Yeah, yeah. It's what we use in our bonds and stuff.
Sergeant Brown, is everybody present? Needs to be present? All right, thank you for your patience, counsels. The court's had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well. Now, stand next to your attorneys. Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What, spell your last name for us?
Susor. Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay, all right. Okay. All right, thank you, sir. Okay, Mr. Susar as well. All right, counsels, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed, and you may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay? If that should occur. Okay? All right. Okay. All right. All right. Is Miss counsels, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss. Thank you, Miss Merchant and Mr. Susar.
Thank you.
Okay. All right.
May we get a copy of that?
Yes. In fact, the clerk is going to file a copy. It's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there, directly download from there.
And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr. Steele.
Sure, that would be great. Thank you so much. Okay, all right. All right, State, is there anything else we need to, or any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony. Where's Miss Bumpus?
You're right. I have a matter.
1 second. Where's Miss Bumpus? She hasn't been released yet.
I'm not certain. Miss Hilton is attempting to determine her whereabouts.
All right, if you could call her, Miss Hilton. Thank you. All right, Mr. Sharp, sir.
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings, and I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully, okay?
Well, Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered.
Sir, that'll be an issue you can certainly raise then and now, but I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing because of the way it was the way it was disseminated. That's why I'm not inclined to do it.
And I would also, I understand the court's ruling. I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape that I know of is maintained by Miss Weaver, who tapes her proceedings in order for her to prepare a transcript. So, okay. Well, I don't know. She may not have any, but we'll see. Okay.
Your Honor, good evening. Carson Matthews on behalf of Mr. Cooley. We were making that same request, Your Honor, for that transcript. We believe it potentially could contain some grading material.
Sure. Okay. All right. Unless there's anything else, counsel?
I join that, and I also believe I advise the court the reason that I also want for confrontation cross-examination is supposed admissions Mr. Copeland made about our case outside our presence, and based upon information and belief, the court handed Mr. Copeland allegedly the long false swearing and perjury, and if that's true, I'd like to also talk with him, if he'll talk, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information and belief.
Madam.
Your Honor, there was no matter to which either counsel for either of the defendants was a party. There was no matter to which either defendant in this case was a party that was had or held outside this courtroom. So we would ask that the court deny what is being requested of the court, because that is something to which neither defendant is entitled.
Your Honor, the witness is on the witness stand. Your Honor, the witness is on the witness stand. The witness is testifying under the RICO Act, which covers all of the defendants. It's understanding upon information and belief that that particular witness has stated again on Friday that he was not going to testify. Today, it was a different scenario, and based upon it, Your Honor, we believe that we should be entitled to that on the writing because we believe it's potential Brady material.
All right, sir.
And it's covered under the RICO statute. He's testifying against all of these defendants under RICO. So we all are part of this witness's testimony.
Your Honor, I would additionally point out that the question to which Mr. Copeland asserted a Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
Yeah. All right. I'm going to deny your motion, at this time, Mr. Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman was sworn in as a witness against all of our clients. He is sworn in as a witness specifically against Mr. Stillwell. Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients, we are certainly a party.
Okay.
And we were denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. All right. Anything else?
We would ask for a copy of that transcript since it's germane to the contempt. So we will be asking for that in the court order. I assume it's this court order, since that is.
It's an ex parte matter, so you're not going to get it unless the appellate court wants to see it, if it's accepted. So, but I'm not going to give it to you at this point in time.
Your Honor, I assume the Harvey rule applies to
Yes, sir.
questions. Thank you.
All right. All right. See y'all tomorrow morning, okay? 9:30 for an anticipated 10 o'clock start time? Okay, we're in recess.